Good evening, ladies and gentlemen. My name is Sabra Mustafa Ismail, and today I'll be examining the validity and legal complexities surrounding two distinct wills created by the late Anthony. Before delving into the analysis, I'll outline the key facts to establish context. In 2018, Anthony, the testator, formally executed a will in the presence of two friends, Bob and Charlie, and appointed his cousin David as the sole executor. Through this will, Anthony expressed his intent to leave all his assets, both movable and immovable, to Bob, Charlie, and his future wife. Although Anthony and his witnesses followed the formal steps by having him sign the will first, Charlie was unable to subscribe at the time due to a sudden call and only signed the next day at his home in Anthony's presence. In 2020, Anthony married Stella. Their relationships faced significant turmoil, leading Stella, during a dispute in 2022, to destroy the original will. This further strained their relationship, and Anthony filed for divorce in 2023, unaware that Stella was pregnant with his child. In 2024, Anthony drafted a second will, designating David as both executor and sole beneficiary. This time, he selected Ed and Fred as his witnesses and signed in their presence. However, upon hearing news of Stella's labor, Anthony left urgently for the hospital, leaving Ed and Fred to complete their signatures without him present. Tragically, Anthony was involved in a fatal accident on the way. This brings the question, how will Anthony's estate be divided considering the questions surrounding the validity and potential revocation of his wills? Before I begin, there is a need to familiarize ourselves with the governing statutes for wills and estate distribution in Malaysia. The Wills Act 1959 is the primary legislation relating to the law on wills. The Wills Act 1959 in itself is substantially influenced from the English Wills Act 1837. It is pertinent to note that the Wills Act is only applicable in Peninsular Malaysia, with Sabah having the Wills Ordinance and Sarawak the Administration of Estates Ordinance. This video aims to explore issues within the 2018 and 2024 will while exploring the validity of each will and how these issues might affect the distribution of Anthony's estate. The first thing we're going to focus on is whether the formalities of a will have been met. Section 5 of the Wills Act provides formalities that need to be complied with in order to execute a valid will. Section 5 of subsection 1 provides that a will must be made in writing. As per the facts of the case, while the Wills Act does not define exactly what writing means, the facts of the case suggest that Anthony drafted his own will and it was made in writing, satisfying the rule under this section. Section 5, subsection 2 of the Wills Act mandates the presence of two or more witnesses for the valid execution of a will. It further requires that these witnesses must be present concurrently, signing the will in the testator's presence, and only after the testator has either signed or acknowledged the document. Here, it is established that Anthony executed the will with his two chosen attesting witnesses, Bob and Charlie, fulfilling this aspect of the statutory formalities. The issue then arises regarding Charlie's act of assigning the will outside of Bob's presence, raising questions about the compliance. As noted in Dr. Shan Muganathan and Pariyasamy Sitambran Pillai, the High Court accepted the attestation of multiple witnesses who confirmed that the will met proper execution standards. The court's interpretation emphasized that while two witnesses must indeed validate the will by signing it in the testator's presence, it does not necessitate their simultaneous presence. Applying this interpretation, Charlie's act of signing in Anthony's presence without Bob present does not invalidate the will, as Section 5 subsection 2 requires that each witness signs in the testator's presence. Furthermore, Section 9 of the Wills Act provides that a witness or their spouse attesting to a will cannot be named as a beneficiary. Any beneficial interest given to such a witness or their spouse is rendered void to avoid conflicts of interest and preserve the testator's intentions. Witnesses are expected to remain impartial, hence receiving a benefit from the will they attest would undermine this principle. Section 9 further holds that while an attesting witness may serve to validate or invalidate a will, it is unconscionable for them to gain from it. As is cited in the case of Harjinder Kaur, Sham Singh and another, and Balvinder Singh, Sham Singh and others, and another appeal, the gift made to the attester's spouse will be nullified. In this case, both Bob and Charlie, the will's witnesses, are also named as beneficiaries. Thus, the beneficial interest granted to them will be voided, nullifying their entitlement under the will. This, however, does not impact the validity of the will itself, which remains effective until legally contested otherwise. Next, the possible revocation of the 2018 will needs to be examined at a twofold. One, would the act of Anthony's wife, Sheila, tearing and flushing down the will revoke the 2018 will? Under Section 14 of the Wills Act, a will may be revoked if the testator or another person in the testator's presence and at their direction destroys it with the intention of revocation. This includes acts of tearing, burning, or otherwise rendering it unusable. Here, Stella's act of tearing and flushing the will amounts to a clear act of physical destruction. However, the critical issue lies in whether this act was directed or intended by Anthony. There must be animus revocandae, the intention to destroy the will. Based on the facts, Anthony instructed Charlie to keep a copy of the will because he, quote, might amend the terms of the will. This may invoke the assumption that perhaps Anthony did have motivation or intention to destroy the will. While Stella's action of destroying the will was in Anthony's presence, there is no indication from the facts that Anthony intended this as an act of revocation. According to the case of Cheese and Lovejoy, the mere physical destruction of a will does not suffice for revocation. The act must be coupled with clear intention to revoke. Anthony's instruction to keep a copy of the will in case of future amendments does not imply a present intent to revoke. This statement suggests possible future changes rather than an immediate desire to nullify the will, failing to meet the threshold for animus revocandae as required by law. The second prong of the possible revocation of the 2018 will is, would Anthony's marriage to Stella revoke the 2018 will? Section 12 of the Wills Act provides that marriage generally revokes an existing will unless certain exceptions apply. The law assumes marriage fundamentally alters a testator's legal obligations and may lead to new intentions for distribution of their estate. An exception to this revocation rule occurs if the will is made expressly in contemplation of marriage to a particular individual, preventing automatic revocation. In the case of Sallies and Jones, the court held that for this exception to apply, the contemplation of marriage must be expressly stated in the will. In Anthony's case, the 2018 will included a reference to his future wife. However, for the exception to apply, he must specifically contemplate a marriage to Stella or a particular individual rather than a general future spouse. Given the facts, the marriage to Stella likely revokes the 2018 will under Section 12 as it does not meet the specific contemplation requirements that were mentioned in Sallis. Given the close similarity between Section 12 of the Wills Act and Section 18 of the English Wills Act 1837, both statutes may warrant similar amendments. The 2023 Law Commission consultation paper highlights that the rule under Section 18, which also extends to Section 12 of the Malaysian Act, has remained unmodified since its enactment, despite evolving societal conditions. The consultation paper notes that a lack of awareness about these sections could lead to misunderstandings, with many assuming their will remains valid post-marriage, ultimately resulting in unintended estate distributions that contravene the testator's intentions. Some of this can be applied in Anthony's case. Despite his failure to name Stella specifically, he nonetheless indicated an intent to allocate a portion of his estate to a future spouse. This intent suggests that the provisions in Section 12 may not fully align with his broader testamentary intentions. The Law Commission's report suggests that a more equitable approach should be applied to the interpretation and application of Sections 12 and 18 of the Wills Act in both Malaysia and England. Now, similar to the approach taken in the 2018 will, we are going to examine whether the necessary legal formalities have been met in the 2024 will. Pursuant to Section 5, subsection 2 of the Wills Act, the execution of a will mandates the presence of two or more witnesses. The authoritative English case of Hindmarsh and Charlton established that for a will to be validly executed, the testator must sign in the presence of the witnesses. In the matter at hand, while Anthony duly signed the will in the presence of his witnesses, Ed and Fred, the critical issue arises concerning the circumstances under which the witnesses affix their signatures. According to the facts presented, the witnesses signed the will in the absence of the testator. This raises significant concerns under Section 5, subsection 2, as statutory requirements stipulate that witnesses must sign in the presence of the testator. Although witnesses are not obligated to sign in each other's presence, the law clearly requires that their signatures be affixed while the testator is present. At the same time, the case of Dr. K. Shan Muganathan and Periasamy Sitambran Pillai, the courts reiterated the same principle as laid down in Section 5, subsection 2. Consequently, this defect within the formalities does not satisfy the statutory requirements for valid attestation, rendering the will invalid. Now, what rights would the parties have if the will was valid? Section 23 of the Wills Act allows for an executor to be named as a beneficiary under the will. It further presumes that where an executor is also a beneficiary, that the will intends to grant the executor a full interest in any bequeathed property unless the document explicitly specifies otherwise. Here, the will provides that all of the testator's property, both movable and immovable, should pass to David. Therefore, under the presumption in Section 23, David would generally be entitled to inherit Anthony's property, assuming the will was valid. Now, with the 2018 will, it's tough to emphasize what rights the parties would have in the 2018 will, because unlike the 2024 will, the issue here does not lie with formalities, but rather it lies on the revocation. Therefore, it is difficult to pronounce how the will would have been distributed. It has been established that neither the 2018 nor the 2024 will fulfill the requirements of a valid will. Specifically, the 2024 will is invalid as the witnesses failed to sign it in the testator's presence, and the 2018 will has been revoked by Anthony's marriage to Stella. Consequently, Anthony is deemed to have died intestate, necessitating reliance on intestacy laws to determine the distribution of his estate. Since Anthony was domiciled in Malaysia, the relevant governing statute is the Distribution Act 1958. Under Section 6 of the Distribution Act, a spouse and issue are among the entitled beneficiaries of an intestate estate. This raises 2 points of consideration. One, whether Stella, despite Anthony's filed divorce petition, is still legally recognized as his spouse, and two, whether Georgina has a claim to the estate as Anthony's child. Anthony had initiated divorce proceedings by filing the required papers, yet the petition had not been heard by the court at the time of his death. For a divorce to be finalized, a decree nisi must be issued, declaring the couple legally divorced. As Anthony passed away before his petition could be addressed, he and Stella are still recognized as married. Therefore, under Section 6, subsection 1, subsection E of the Distribution Act, Stella is entitled to 1/3 of Anthony's estate by virtue of intestacy. Before we delve into whether Georgina has any entitlement to the estate, it is pertinent to note that Section 2 of the Distribution Act 1958 provides that the definition of a child is a legitimate child of the offspring. Additionally, Section 6, subsection 1, subsection E of the Distribution Act mentions that if an intestate dies, leaving a spouse and an issue, then the issue is entitled to two-thirds of the estate. The word issue means a child of the intestate. Based on the facts, Georgina appears to be the legitimate child of Anthony and is therefore entitled to two-thirds of his estate. In conclusion, Anthony's situation highlights the complexities of estate planning and how formalities can alter how an estate is divided. The 2018 will and the 2024 will did not meet the necessary legal requirements and is therefore treated as though Anthony passed without a will. This shifts his estate distribution to the intestacy laws under the Distribution Act, which gives Stella and Georgina specific shares of his estate by law. Thank you very much.